In a medical malpractice case, if your recollection of the events that occurred are significantly different than the doctor's version of the events, what happens then? Who is more believable? Are you more believable? Is the doctor more believable? Or something else? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Credibility plays a very significant role in these lawsuits, these civil lawsuits involving medical malpractice, accident matters, and even wrongful death matters. A jury, if your case goes to trial, a jury will ultimately have to determine who is more believable. Are you slightly more likely right than wrong than what the doctor is saying? Is your medical expert slightly more likely right than wrong than what the defense expert is saying? Who is more believable? That is the critical and central focus of your entire case. If a jury deems you and your medical expert to be more believable than the defense, in all likelihood they will come back for a verdict in your favor. If, however, the jury determines that the doctor whom you have sued and his medical expert are more believable, more credible, then in all likelihood they will achieve a more favorable verdict than you have. So why is it that the jury determines who's more believable to decide whether or not there was carelessness, to decide whether the carelessness was a cause of your injury, and to decide the extent of your injuries and how substantial and significant they were? Well, our system of justice has this issue. You, in your heart of hearts, believe that something was done wrong. A medical expert who has reviewed all your records confirms that you have a valid and meritorious case. Now, the doctor disputes everything that you have claimed. The doctor says, I did nothing wrong, and even if I did something wrong, whatever I did not cause you harm and injury. And then he said, even if I did something wrong, and whatever I did caused you injury, your injuries really are not as bad as you claim them to be. By the way, those are called affirmative defenses. So now there are clear disputes. You believe something was done wrong, the doctor says nothing was done wrong. You believe that his actions caused you injury, the doctor says whatever I did not cause you injury. You say that your injuries are permanent and significant, the doctor says even if I did something wrong and I caused you harm, your injuries are nowhere near as bad as you claim them to be. So there are factual disputes. There are medical experts who dispute the facts. Now this I always find fascinating. I've been doing this now for 36 years, and I will tell you, here we have one set of facts, and based upon those one set of facts, a medical expert on behalf of the injured patient will reach one conclusion favorable to the injured patient. Using those same exact set of medical facts, a doctor, an expert on behalf of the people you have sued, the physicians you have sued, will reach a totally opposite conclusion. So now, with all those factual disputes, it will be up to a jury. This is a civil case, this is not a criminal case. A jury in New York has 6 members of the community who are there to sit in judgment to decide who is more likely right than wrong. That's their function. And part of their job will be to determine, number one, whether the doctor you have sued was in fact careless. Did he depart from the standard of care? Yes or no? If the answer is no, your case is finished and you lose. If the answer is yes, that the doctor was careless, that he departed from the standard of care, the jury then has to evaluate whether or not that carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. If the answer is no, that means that they have determined that although your doctor was careless, that carelessness did not cause your injury, which means you lose and you receive nothing as compensation. On the other hand, if the jury comes back and says, yes, the doctor was careless, and yes, as a result of his carelessness, you suffered harm and injury, now the next question they will have to answer is, what is the extent of your injury? You believe that your injuries are worth X millions of dollars, and now the defense may argue, okay, we recognize that you have this injury, we don't believe we caused it or contributed to it, but if, jury, you believe that all of these steps occurred and now this patient suffered injury because of the doctor's carelessness, we would argue that this patient's injuries are nowhere near as significant as they claim it to be. So the jury will then have to determine the value of your particular injuries. And again, these are factual disputes, and you will hear testimony at trial from each side about medical doctors who are treating the patient, from medical experts. The jury will have to make decisions about who they believe. It's all about credibility. And now, if the jury determines that you are more credible, you will likely wind up with a verdict in your favor. If, however, the jury determines that the doctor and his experts are more credible, it is likely that the defense will wind up with a verdict in their favor. So why is this important? It's important for you to understand. So let's get back to the question I raised in the title of this video. Your recollection is that when you presented to the doctor, you told him about a lump in your breast and the left breast at the 12 o'clock position. The doctor says, no, you did not present with any particular complaints of any lump in your breast. If you had done that, he would have written and recorded that information. You turn around and say that the doctor did not perform any breast exam. The doctor says, on the other hand, of course I did a breast exam. That's what I always do when a female patient comes in, and now as part of my routine exam, I always do a breast exam. I do it with the patient sitting up, and I do it with the patient sitting down. And you, on the other hand, turn around and say, no, I remember specifically, and my mother was with me, and she can vouch for the fact that this doctor did not do a physical examination of me. However, the doctor's records in this hypothetical example says, yes, he did an examination of your breasts, not just sitting up, but also lying down. And in the doctor's records, it does not reflect that you complained of any particular lump in your left breast. You have alleged in your particular case that the doctor failed to take action and do the right thing after telling him about this lump in your left breast. The doctor says, listen, she did not come in and make such a complaint. I did a breast exam and there was nothing there. I don't know what she's talking about. Who is more believable? That will be up to a jury to ultimately decide. The jury will have to evaluate the records. They will have to evaluate the doctor's credibility and his presentation, as well as your own. And they will have to determine who is more believable. If they believe your version of the events, again, you are much more likely to achieve an outcome that is favorable. If, however, the jury believes the doctor, you are much more likely to achieve a less favorable result, but one that is favorable to the doctor. So in almost every single one of these medical malpractice cases, these accident cases, these wrongful death cases, there are clear factual disputes that often require a jury to determine and to evaluate. It is up to the jury. The jury is the trier of facts. And although they don't wear black robes sitting in the courtroom, they are the only ones who are going to be deciding what the real facts are and who is more credible than the other. So why do I share this quick information with you? I share it with you to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have an amazing day.